Hello, I'm Dana Sparks, Managing Broker of Maximum One Realty Greater Atlanta. And today's contract tip has to do with the revision in the purchase and sale agreement that GAR just made this month, May of 2015. It has to do with closing in possession. As you know, or may not know, but if you're using the GAR contracts, hopefully you do know, that in the contracts to change the closing date, the buyer and the seller do agree to a unilateral extension of the closing date. Again, this is in the Georgia Association of Realtors 2015 Purchase and Sale Agreement, Form F20. Now, this provision has been allowed for in previous contracts. The change that they just made this month is that the unilateral extension of the closing date is for an 8-day period rather than a 7-day unilateral extension. Now, the parties may not just unilaterally extend for any reason. There are specifications regarding why and under which circumstances a party may utilize this provision. Paragraph B6A states right to extend the closing date. Buyer or seller may unilaterally extend the closing date for 8 days. Again, that is a change. Previously, it had been 7 days. Upon notice to the other party given prior to the date of closing or on the date of closing. Now this is the provisions under which one or the other party may utilize this unilateral notice to extend. Seller cannot satisfy valid title objections, excluding title objections that A, can be satisfied through the payment of money or by bonding off of the same, and B, do not prevent the seller from conveying good and marketable title as that term is defined herein. And also in the GAR, Georgia Association of Realtors contracts, it specifically defines good and marketable title as in which a title insurance company licensed to do business in Georgia will insure at its regular rates, subject only to standard exceptions. So let me back up. The only reasons by which a seller or buyer may use the unilateral extension is if the seller can't satisfy valid title objections, as long as they can't just pay to satisfy a lien or bond off the lien, or does not prevent seller from conveying good and marketable title as that term is defined herein, which I just read to you. 2, the buyer's mortgage lender, if any, including all cash transactions, or the closing attorney, obviously in an all cash transaction, cannot fulfill their respective obligations by the date of closing, provided that the delay is not caused by the buyer. Or 3, the buyer has not received required estimates or disclosures and buyer is prohibited from closing under federal regulations. The party unilaterally extending the closing date shall state the basis for the delay in the notice of extension. If the right to unilaterally extend the closing date is exercised once by either buyer or seller, the right shall hereafter terminate. That means this is a last resort to extend your contracts. First resort would obviously be by amendment, by agreement between the buyer and the seller to extend the contract. Barring that, this unilateral right comes into play, unilateral meaning only requiring one party's signature. The other thing to be careful of, agents, is although this change, Georgia Association of Realtors Forms Committee made this change that when the buyer and the seller sign the contract and get a binding agreement under this form, they do agree to this 8-day unilateral extension. However, they did not alter the form, the actual notice for unilateral extension, and that still says 7 days. So just be careful of that, and you will have to change that to 8 days if you're actually using that form, because the buyer and the seller have already agreed to that. So good luck. Hope you enjoyed this contract tip for the day. And again, I'm Dana Sparks, Managing Broker of Maximum One Realty Greater Atlanta.